Defense Act. Okay? And clearly, we have already vibrations from the panelists that this is something which, as Thierry says, was very clear in terms of what is the interest of US industry, but can be seen as a collective optimum contributor. What are your views of what would be the impact, not just in the US, but regionally and possibly globally of this act?
Probably the biggest one that comes to mind is we are hoping and we are optimistic that the America Invents Act will allow less litigation of intellectual property rights in the United States. Our federal district court judges, these are big cases for them. They take a lot of time. Not all judges like handling our patent cases, and not all issues have to go to our courts. Because oftentimes between two parties, new information becomes available. And what the America Invents Act, I think, provides, and that I personally am optimistic that it will be effective, is that if there new information, a new reference, a new piece of prior art suddenly comes to an attention of a third party, and they think that information now puts into question a valid patent and the claims that we issued, the America Invents Act now has these trial procedures in our Board of Patent Trial and Appeal Board, not our Central Reexamination Unit. This is actually not before our highly experienced examiners. It's before our appeals judges. We get a panel of 3 appeals judges. They're all administrative law judges. And they're able to look at the new information, decide whether or not it meets a threshold, whether it can affect the patentability, and if they think it does, they're able to start one of these trial procedures in the U.S. Patent and Trademark Office, and it has to be completed according to Congress within 12 months. So you can still have limited depositions, limited discovery, limited electronic discovery, and our judges will help the parties decide what's appropriate. We do not want a $1 million electronic discovery issue in the middle of one of our trials. I guarantee you, our judges, that would be inappropriate to have that in the patent office. We want to keep the costs down. We want to look at the work we did before in view of the new information and determine if the claims should remain. They're still valid. They still should have been allowed. They're still patentable. Alternatively, we'll allow the patent owner to amend their claims, and so we may think the amended claims are patentable, or in view of the new information, it's possible that none of the claims would survive. So I think that what we tend to hear about intellectual property, and I think, Pedro, you mentioned the image of IP, or the image of IP is not particularly good right now in all sectors of society, and sometimes the fact that there's litigation in the United States, they think there's too much litigation. You will never remove all intellectual property litigation, because that body of case law helps us interpret our statutes, and it's necessary at times because business is getting more innovative and creative, and attorneys are also getting more innovative and creative. And you can never anticipate the future. So at any rate, I think that that's probably going to be the most beneficial aspect of the America Invents Act. It just went into effect September 16th of 2012, and I believe we have about 33 trial procedures that have been filed to date. That information is all available on the U.S. Patent and Trademark Office website, and we have a system there called PRPS, and I apologize that I don't recall what that acronym means because it's new, but I work for the federal government, so we do acronyms well. So PRPS, and on the U.S. Patent Office website, to those of you who actually do IP, or your people in your office do, you can actually look and see what has been filed so far. What's the petition? What's the prior art? What's the expert reports attached to it? We've got embedded links so everyone can see what's been filed so far, because we want to be completely transparent with these, and we want people to see how they evolve, and we plan on handling them well, so you will come to us for more business and go less often to the U.S. District Court.
Thank you very much. So clearly, and this is also something we heard from the previous panel, has been repeated here, diminishing transaction cost is a clear objective that business and governments will recognize worldwide as a common objective. So by pursuing this effort, it's not just the EU, the US, or individual countries in Europe who are making an effort, self-serving effort. They are also contributing something that can be considered as a common public good for the rest of the planet. So it's probably one element that may gain prominence when we have these debates about is IP on the dark side of the force, etc. There are elements in the current debate that everybody will recognize as positive. So that's probably one element to get into the debate. I remember at some point with some colleagues at the World Bank and other international organizations, we created the International Association of People Who Hate Acronyms. And we called it, of course, IOAPWA. So we can sympathize with that. Let me come back to a point that has been mentioned already by several panelists, which is about the true link between IP and innovation. We heard from GE, for instance, the way in which, with the DNA of Thomas Edison running in your veins, you are actually looking at ways in which you can reinvest what you get out of IP into a true innovation process. Do you feel that this is an exception? Do you feel that we have another type of business entity, and I'm not mentioning just trolls, or way that companies could be called trolls, where you have a disembodiment of what is actually the fabs, creating something as opposed to getting a rent out of intellectual property and in particular patents. Is that, and I'm not pointing the finger at GE, but do you feel that we have the two possibilities and types of companies emerging?